Breaking news out of New York State. Governor Kathy Hochul and her friends in the New York State legislature appear to be starting a strategic retreat. I repeat, a retreat away from the crazy gun control laws that they enacted in a hissy fit in response to the Supreme Court spanking of New York in the case of NYSERPA versus Bruin. Stay tuned. I'm going to explain to you why Kathy Hochul appears to be starting a hasty retreat. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner and constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner, please do so. We're trying to hit 100,000 subscribers as soon as possible to help us with the social media algorithms. All right, folks, breaking news out of the state of New York. Not a legal case, but a response to the legal cases where New York State is largely getting spanked in the courts. Of course, we know there's 5 cases pending right now before the United States Court of Appeals for the Second Circuit to determine all sorts of things about the future of New York's gun control laws, especially their so-called sensitive places, which is a euphemism, of course, for government-mandated gun-free zones. But the breaking news is this. Kathy Hochul and her state legislature friends have proposed a 2024 New York State executive budget, a proposal dealing with public protection and general government. That's what she's supposedly doing. And what do we find in this massively long, crazy document for fiscal year 2024 for the state of New York, as proposed by Governor Hochul? Turns out they're trying to amend their gun control laws. Wonder why? Well, it turns out that they're trying to fix, quote unquote, fix some of the silly errors that they made when they drafted in haste, without serious consideration as I see it, their gun control laws after NYSERPA versus Bruin. The Supreme Court spanked the state of New York for violating the Second Amendment's right to keep and bear arms. Now, as you remember, New York did several things. One of the things they did is basically try to define the entire state of New York as a sensitive place or gun-free zone, which the Supreme Court specifically told them they could not do in the opinion of NYSERPA versus Bruin, but they did this anyway. And they've been getting a lot of pushback. And it turns out that in this fiscal year 2024 budget, Kathy Hochul has decided to try to engage in a strategic retreat to at least fix some, not nearly enough, by the way, but some of the most absurd mistakes they made in rushing through their crazy gun control law after NYSERPA versus Bruin. Let me just give you a couple of examples and a couple other ideas as I went through this ridiculously long document. After all, it's New York State, the nanny state, one of the nanny states out there, and I can't imagine how big their budget's going to be, but I'm sure it's going to be full of bloat and waste. But I digress. Okay, first thing they're going to do is they're writing into the law specifically when it comes to gun-free zones dealing with churches. As you know, places of worship are one of the sensitive places. They want to amend that law in the state of New York to add the language that says that any place of worship for religious observation is a sensitive place, gun-free zone, except for those, this is the new language, except for those persons responsible for security at such place of worship. Well, of course, if you remember, in the appeal to the Second Circuit, that was written into, so in the court cases, New York has already conceded this point. It looks like what they're basically doing is they're writing into statute what New York State has already conceded in courts that they refuse to defend. Now, if I was running a church, a synagogue, or a mosque, I would just designate every adult to be responsible for security and let them carry guns. But again, that's just me, but I'm not in charge of a place of worship in the state of New York. So I don't have to worry about those laws or follow them in that sense. So again, but that's what I would be looking to do if I ran a place of worship. I would certainly be looking to designate anyone that wanted to participate in security. I would be looking for a way to allow them to do that under the law appropriately. So New York is apparently exempting from a lot of the sensitive places and some of the other laws. Anything that applies to qualified law enforcement, either retired or active under the LEOSA statute, that's the Law Enforcement Officer Security Act, I believe, or Safety Act. Those are being exempted, meaning they are allowed to go in certain sensitive places that ordinary Americans cannot go. The other thing that New York Kathy Hochul appears to be proposing with this legislation is expanding the scope of places that people with hunting license can go when they're engaged in the process of hunting. It looks like they're expanding that. They're also expanding the number of places that people can go if they're legally engaged in things such as hunter education, marksmanship practice, marksmanship competitions, or training for the purposes of safe handling and use of firearms. It looks like they've expanded the scope of places that you can bring your gun outside of the scope of sensitive places. They've expanded where you're allowed to bring under New York law. At least that's what they're proposing here as I read this draft statute. They've also exempted other government agents from sensitive place rules, including revenue agents, security departments, the MTA, which is the people that police the buses and subways, and also the New York City Transit Authority and the like. What's also interesting, and this is another fascinating example, New York is now exempting from their sensitive places laws, at least to some degree, people that are engaged in the activities of historical reenactments. There was a big debate about whether or not people that wanted to historically reenact battles in New York State, whether or not they would legally be allowed to. This amendment to the statute would make it clear that they would presumably be allowed to do so. Also, people engaged in motion pictures would also be allowed to use firearms in the context of filming motion pictures or in theatrical productions. I presume that refers to things like Broadway plays and musicals and the like. That means, I guess, people that are using guns at Annie Get Your Gun in Oklahoma would indeed be able to use firearms in the context of their performances. Beyond that, it also is exempting from certain sensitive place rules, apparently. They're also exempting people who are engaged in official work associated with the display of antique firearms, rifles, or shotguns at museums or historic sites. I presume that means like the people that work at the Metropolitan Museum of Arts are allowed to handle firearms in the context of displaying arms in conjunction with the museums or any historic sites in the state of New York. Presumably Fort Ticonderoga would have some firearms up there, and that would all be exempt. They've also exempted people that are engaged in military ceremonies, funerals, and honor guards so that they are allowed to handle firearms and not go to jail. The next thing, which is kind of a weird one, but it's in here, anyone that's engaged in learning, practicing, exercising, training for, competing in, or traveling to or fro competitions associated with the sport of biathlons are also exempted from certain sensitive places rules. And what's fascinating about this, and I think this is actually quite helpful for the home team, the Second Amendment community, is they are specifically finally saying that Adirondack Park, which I believe has about 2 million acres, and the Catskill Park, which has like 700,000 acres, these are no longer going to be designated sensitive places. At least there may be some restrictions, but they are at least no longer just a sensitive place. Obviously, the absurdity of making something which has 2 million acres or 700,000 acres a sensitive place in the middle of nowhere is obviously absurd, but that's what New York did. Again, I think these changes just illustrate how New York State rushed to judgment. They rushed through this legislation, and although I don't think it's specifically directly relevant to the litigation going on involving the sensitive places that we're seeing in the Second Circuit Court of Appeals and beyond, I do think it's telling that New York was sloppy when it enacted this. And of course, we all know that virtually all of the so-called sensitive places that New York designated as gun-free zones after Bruin, almost none of those were sensitive places, gun-free zones before Bruin, which is, to me, strong evidence that none of these things are really sensitive places. It's just New York State throwing a hissy fit in response to getting slapped around by the U.S. Supreme Court in NYSERDA versus Bruin. I also want to note that they've exempted peace officers and law enforcement officers from licenses associated with procuring semi-automatic rifles. Last but not least, what's interesting is they made a point repeatedly, this is kind of interesting, they made a point repeatedly to exempt from any profession that's allowed to be exempted from, so it's an exception from an exception, anyone that's in the so-called unorganized militia as defined by New York's military law. Now, I should note that under New York's military law, this is New York State's, not the feds, New York State specifically defines the unorganized militia as all able-bodied male residents of New York between the ages of 17 and 45, but these exemptions for military and the like specifically say that if you're only in the unorganized militia, it doesn't count. You're not allowed to benefit from any of the military, law enforcement, or government agent exemptions that New York is creating. Isn't that quite cute? Two additional points here. One is that they talk about the unlawful purchase of body armor and specifically, again, create some exemptions for government agents. One wonders how is body armor not a protected arm given that Heller defines arms as things that can be used offensively or defensively, among other things. It seems to me body armor should be protected by the Second Amendment, although I don't think there's any litigation going on that I'm aware of in New York State over this, but that seems to be something that is quite doable, because after all, I mean, body armor is purely defensive, right? And why should government agents have the benefit of being protected by body armor from crazy psycho terrorists on our streets, the same streets that you and I walk on, but we can't be protected by body armor? It seems like they want ordinary Americans who don't work for the government to die, which is why we're not allowed to wear body armor according to New York, apparently. But if you work for the government, you are allowed to have body armor. I think that's shall we say, not exactly fair and equal treatment, but I digress, and maybe we'll talk about body armors in an entire separate segment later. And last but not least, I found this also fascinating that they, you know how in the state of New York, in many places, it takes months, maybe even years to get your license after Niserva versus Bruin. We'll see what happens. That may be changing, but for the moment, there's very long delays in some parts of New York in terms of getting your concealed carry permit. But nevertheless, this is going to be interesting, because here we have, as part of Kathy Hochul's fiscal year 2024 budget for the state of New York, she is proposing to add a law that requires within 72 hours, I repeat, within 72 hours of any kind of a shooting, the police, the law enforcement agents of the state of New York will be required to type in all sorts of information into a database. Again, a 72-hour requirement. It specifically says that this data involving firearms misuse, as they say, shall be done in no case more than 72 hours after the agency has determined that the firearm, rifle, or shotgun discharge occurred in connection with a criminal offense. And the things that have to be typed into the state database include everything from the location of the incident, the nature of the criminal offense, the nature and extent of the injuries, the firearm, rifle, shotgun manufacturer, model, serial number, caliber, and any other ammunition associated with it, whether the arrest has been made, whether the firearm, rifle, or shotgun has been recovered, and so on and so on and so on. So it seems like they're far more interested, the state of New York, in devoting resources to recording criminal violence as opposed to going out there and stopping it. Because, as I would argue, that every minute that a police officer is spent typing up this database of gun violence, quote unquote gun violence, is an hour that they're not out there on the streets actually protecting Americans and taxpayers in the state of New York from criminals, terrorists, psychos, and other people that will do them harm. Instead, they'll be sitting behind a computer doing a keyboard commando thing, typing up this information for the state of New York that Kathy Hochul wants. Okay. Bottom line is, New York has obviously decided they have to amend and shrink the scope of their sensitive places law because of some of the legal pushback they're receiving. This doesn't go nearly as far as I would like to see it go, but it is an example of New York is conceding certain points and shrinking the scope of their gun-free zone. Obviously, I think that's going to continue to shrink as court victories come in. I do think there will be more court victories against the state of New York under the Second Amendment, but I think it is at least a good sign that New York is shrinking the scope of their gun control laws. Not nearly enough, but at least it's moving in the right direction for the moment, based on this 2024 proposed fiscal year budget by Governor Hochul. Okay, hope you learned a little bit something here about where things are going in New York. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.